So some of the specifics then in this webinar will involve looking at fact-finding hearings and prohibition of cross-examination. What's the current position on that? We'll look at the guidance by the President on fact-finding hearings and domestic abuse in private law children cases. We'll look at cross-examination and children law cases, particularly where the Domestic Abuse Act 2021 lies, and the use of QLRs, the qualified legal reps. Where do we stand with standard orders in cases involving prohibition of cross-examination? And then there's a number of online pilots, as you know, that are going through. So we'll consider, for example, Practice Direction 36Z, which is one of the main ones at the moment, and we'll see what the position of getting bundles together, so Practice Direction 27A in relation to children matters. Domestic abuse, as we said, continues to be a feature of this area. So one of the recent cases has been the case of F and M, the case of earlier this year. And then we'll look at fact-finding hearings generally, see how matters have progressed with the K&K case last year, the President's guidance on fact findings, use of Section 9114s, and then we'll look at some of the other areas in private children, parental order surrogacy, parental alienation, enforcement, and then cost orders, as well as the use of experts. Okay, so a number of areas that I'll be covering with you today. Now, I've also mentioned the position surrounding surrogacy, and this case of Re-C, Surrogacy Contact, this 2023 decision. It's a very good case, this one, Re-C, of January this year, because it emphasises the fact that when somebody is applying and seeking a parental order under Section 54 of HFEA, that's the Human Fertilisation and Embryology Act of 2008, it's very important to be satisfied that that person is, of course, giving consent which is unconditional. And here, this was a child, parental order made in respect to a child then under a year old, and the appellant was a surrogate who was the biological mother. Now, she argued that she hadn't given that consent for the purpose of the Act, and she said that although she had allowed for the child to then go to the commissioning family, she did say that part of that approach was that she said that she was promised that she would have certain involvement with a child going forward in terms of having contact, for example. So she consented on the basis that, albeit reluctantly, she said it was given in reliance on the promise of a child arrangements order, and that she gave it conditionally on that basis. And in fact, the court was satisfied on the facts that actually that was the case, and therefore, on that basis, the parental order should not have been made because it was not given unconditionally. So again, it's worth looking at that case.